157. Qualifications for appointment as governor. No person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 35 years. 158. Conditions of governor's office. 1. The governor shall not be a member of either House of Parliament or of a House of the Legislature of any state specified in the first schedule, and if a member of either House of Parliament or of a House of the Legislature of any such state be appointed governor, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as governor. 2. The governor shall not hold any other office of profit. 3. The governor shall be entitled without payment of rent to the use of his official residences and shall be also entitled to such emoluments, allowances and privileges as may be determined by Parliament by law and, until a provision in that behalf is so made, such emoluments, allowances and privileges as are specified in the second schedule. 4. Where the same person is appointed as governor of 2 or more states, the emoluments and allowances payable to the governor shall be allocated among the states in such proportion as the President may by order determine. 5. The emoluments and allowances of the governor shall not be diminished during his term of office. 159. Oath or affirmation by the governor. Every governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court exercising jurisdiction in relation to the state, or, in his absence, the senior-most judge of that court available, an oath or affirmation in the following form, that is to say, I, A.B., do swear in the name of God, solemnly affirm that I will faithfully execute the office of governor, or discharge the functions of the governor, of, name of the state, and will to the best of my ability preserve, protect and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of, name of the state. 160. Discharge of the functions of the governor. In certain contingencies the President may make such provision as he thinks fit for the discharge of the functions of the governor of a state in any contingency not provided for in this chapter. 161. Power of governor to grant pardons, etc., and to suspend, remit or commute sentences. In certain cases the governor of a state shall have the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute the sentence of any person convicted of any offense against any law relating to a matter to which the executive power of the state extends. 162. Extent of executive power of state. Subject to the provisions of this Constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws. Provided that in any matter with respect to which the legislature of a state and Parliament have power to make laws, the executive power of the state shall be subject to, and limited by, the executive power expressly conferred by this Constitution or by any law made by Parliament upon the Union or authorities thereof. Council of Ministers. 163. Council of Ministers to aid and advise Governor. 1. There shall be a Council of Ministers with the Chief Minister at the head to aid and advise the Governor in the exercise of his function, except in so far as he is by or under this Constitution required to exercise his functions or any of them in his discretion. 2. If any question arises whether any matter is or is not a matter as respects which the Governor is by or under this Constitution required to act in his discretion, the decision of the Governor in his discretion shall be final, and the validity of anything done by the Governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. 3. The question whether any, and if so what, advice was tendered by ministers to the Governor shall not be inquired into in any court. 164. Other provisions as to ministers. 1. The chief minister shall be appointed by the governor and the other ministers shall be appointed by the governor on the advice of the chief minister, and the ministers shall hold office during the pleasure of the governor. Provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Orissa, there shall be a minister in charge of tribal welfare who may in addition be in charge of the welfare of the scheduled castes and backward classes or any other work. 2. The total number of ministers, including the chief minister, in the Council of Ministers in a state shall not exceed 15% of the total number of members of the Legislative Assembly of that state. Provided that the number of ministers, including chief minister in a state shall not be less than 12. Provided further that where the total number of ministers including the chief minister in the Council of Ministers in any state at the commencement of the Constitution, 91st Amendment, Act, 2003 exceeds the said 15%, or the number specified in the first proviso, as the case may be, then, the total number of ministers in that state shall be brought in conformity with the provisions of this clause within 6 months from such date as the President may by public notification appoint. 3. A member of Legislative Assembly of a state or either House of the Legislature of a state having Legislative Council belonging to any political party who is disqualified for being a member of that House under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1, for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire or where he contests any election to the Legislative Assembly of a state or either House of the Legislature of a state having Legislative Council, as the case may be, before the expiry of such period, till the date on which he is declared elected, whichever is earlier. 4. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. 5. Before a minister enters upon his office, the governor shall administer to him the oaths of office and of secrecy according to the forms set out for the purpose in the 3rd schedule. 6. A minister who for any period of 6 consecutive months is not a member of the legislature of the state shall at the expiration of that period cease to be a minister. 7. The salaries and allowances of ministers shall be such as the legislature of the state may from time to time by law determine and, until the legislature of the state so determines, shall be as specified in the 2nd schedule. The Advocate General for the State. 165. Advocate General for the State 1. The governor of each state shall appoint a person who is qualified to be appointed a judge of the High Court to be Advocate General for the state. 2. It shall be the duty of the Advocate General to give advice to the government of the state upon such legal matters, and to perform such other duties of a legal character, as may from time to time be referred or assigned to him by the governor, and to discharge the functions conferred on him by or under this Constitution or any other law for the time being in force. 3. The Advocate General shall hold office during the pleasure of the governor, and shall receive such remuneration as the governor may determine. Conduct of Government Business 166. Conduct of Business of the Government of a State 1. All executive action of the government of a state shall be expressed to be taken in the name of the governor. 2. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. 3. The governor shall make rules for the more convenient transaction of the business of the government of the state, and for the allocation among ministers of the said business in so far as it is not business with respect to which the governor is by or under this Constitution required to act in his discretion. 167. Duties of Chief Minister as respects the furnishing of information to governor, etc. It shall be the duty of the Chief Minister of each state. 1. to communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state and proposals for legislation. 2. To furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for, and 3. If the governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Chapter 3. The State Legislature General 168. Constitution of Legislatures in States 1. For every state there shall be a legislature which shall consist of the governor, and a sense in the states of Bihar, Maharashtra, Karnataka, and Uttar Pradesh, 2 houses, a sense in other states, 1 house. 2. Where there are 2 houses of the legislature of a state, one shall be known as the Legislative Council and the other as the Legislative Assembly, and where there is only 1 house, it shall be known as the Legislative Assembly. 169. Abolition or creation of legislative councils in states 1. Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the Legislative Council of a state having such a council or for the creation of such a council in a state having no such council, if the Legislative Assembly of the state passes a resolution to that effect by a majority of the total membership of the Assembly and by a majority of not less than 2/3 of the members of the Assembly present and voting. 2. Any law referred to in Clause 1, shall contain such provisions for the amendment of this Constitution as may be necessary to give effect to the provisions of the law and may also contain such supplemental, incidental and consequential provisions as Parliament may deem necessary. 3. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purposes of Article 368. 170. Composition of the Legislative Assemblies 1. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500, and not less than 60, members chosen by direct election from territorial constituencies in the state. 2. For the purposes of Clause 1, each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as practicable, be the same throughout the state. Explanation. In this clause, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published. Provided that the reference in this explanation to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2026 have been published, be construed as a reference to the 2001 census. 3. Upon the completion of each census, the total number of seats in the Legislative Assembly of each state and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law determine. Provided that such readjustment shall not affect representation in the Legislative Assembly until the dissolution of the then existing Assembly. Provided further that such readjustment shall take effect from such date as the President may, by order, specify, and until such readjustment takes effect, any election to the Legislative Assembly may be held on the basis of the territorial constituencies existing before such readjustment. Provided also that until the relevant figures for the first census taken after the year 2026 have been published, it shall not be necessary to readjust a cents the total number of seats in the Legislative Assembly of each state as readjusted on the basis of the 1971 census and a cents the division of such state into territorial constituencies as may be readjusted on the basis of the 2001 census, under this clause. 171. Composition of the Legislative Councils. 1. The total number of members in the Legislative Council of a state having such a council shall not exceed 1/3 of the total number of members in the Legislative Assembly of that state. Provided that the total number of members in the Legislative Council of a state shall in no case be less than 40. 2. Until Parliament by law otherwise provides, the composition of the Legislative Council of a state shall be as provided in Clause 3. 2. Of the total number of members of the Legislative Council of a state, a sense as nearly as may be, 1/3 shall be elected by electorates consisting of members of municipalities, district boards and such other local authorities in the state as Parliament may by law specify. A sense as nearly as may be, 1/12 shall be elected by electorates consisting of persons residing in the state who have been for at least 3 years graduates of any university in the territory of India or have been for at least 3 years in possession of qualifications prescribed by or under any law made by Parliament as equivalent to that of a graduate of any such university. A sense as nearly as may be, 1/12 shall be elected by electorates consisting of persons who have been for at least 3 years engaged in teaching in such educational institutions within the state, not lower in standard than that of a secondary school, as may be prescribed by or under any law made by Parliament. A sense as nearly as may be, 1/3 shall be elected by the members of the Legislative Assembly of the state from amongst persons who are not members of the Assembly. A sense the remainder shall be nominated by the Governor in accordance with the provisions of Clause 5. 3. The members to be elected under sub-clauses A, B, and C of Clause 3 shall be chosen in such territorial constituencies as may be prescribed by or under any law made by Parliament, and the elections under the said sub-clauses and under sub-clause D of the said clause shall be held in accordance with the system of proportional representation by means of the single transferable vote. 4. The members to be nominated by the Governor under sub-clause C of Clause 3 shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely: literature, science, art, cooperative movement and social service. 172. Duration of state legislatures. 1. Every legislative assembly of every state, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and no longer, and the expiration of the said period of 5 years shall operate as a dissolution of the assembly. Provided that the said period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year at a time and not extending in any case beyond a period of 6 months after the proclamation has ceased to operate. 2. The Legislative Council of a state shall not be subject to dissolution, but as nearly as possible 1/3 of the members thereof shall retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by Parliament by law. 173. Qualification for membership of the state legislature. A person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he 1. Is a citizen of India, and makes and subscribes before some person authorized in that behalf by the Election Commission an oath or affirmation according to the form set out for the purpose in the 3rd schedule. 2. Is, in the case of a seat in the Legislative Assembly, not less than 25 years of age and, in the case of a seat in the Legislative Council, not less than 30 years of age and 3. Possesses such other qualifications as may be prescribed in that behalf by or under any law made by Parliament. 174. Sessions of the State Legislature, Prorogation and Dissolution. 1. The Governor shall from time to time summon the House or each House of the Legislature of the State to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. 2. The governor may from time to time prorogue the House or either House dissolve the Legislative Assembly. 175. Right of governor to address and send messages to the House or Houses. 1. The governor may address the Legislative Assembly or, in the case of a state having a legislative council, either House of the legislature of the state, or both houses assembled together, and may for that purpose require the attendance of members. 2. The governor may send messages to the House or Houses of the legislature of the state, whether with respect to a bill then pending in the legislature or otherwise, and a House to which any message is so sent shall with all convenient dispatch consider any matter required by the message to be taken into consideration. 176. Special Address by the Governor. 1. At the commencement of the first session after each general election to the Legislative Assembly and at the commencement of the first session of each year, the governor shall address the Legislative Assembly or, in the case of a state having a legislative council, both houses assembled together and inform the legislature of the causes of its summons. 2. Provision shall be made by the rules regulating the procedure of the House or either House for the allotment of time for discussion of the matters referred to in such address. 177. Rights of Ministers and Advocate General. As respects the Houses, every Minister and the Advocate General for a state shall have the right to speak in, and otherwise to take part in the proceedings of, the Legislative Assembly of the state or, in the case of a state having a legislative council, both houses, and to speak in, and otherwise to take part in the proceedings of, any committee of the legislature of which he may be named a member, but shall not, by virtue of this article, be entitled to vote. Officers of the State Legislature. 178. The Speaker and Deputy Speaker of the Legislative Assembly. Every Legislative Assembly of a state shall, as soon as may be, choose 2 members of the Assembly to be respectively Speaker and Deputy Speaker thereof, and, so often as the office of Speaker or Deputy Speaker becomes vacant, the Assembly shall choose another member to be Speaker or Deputy Speaker, as the case may be. 179. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. A member holding office as Speaker or Deputy Speaker of an Assembly. 1. Shall vacate his office if he ceases to be a member of the Assembly. 2. May at any time by writing under his hand addressed, if such member is the Speaker, to the Deputy Speaker, and if such member is the Deputy Speaker, to the Speaker, resign his office and 3. May be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly. Provided that no resolution for the purpose of clause C shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. Provided further that, whenever the Assembly is dissolved, the Speaker shall not vacate his office until immediately before the first meeting of the Assembly after the dissolution. 180. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker. 1. While the office of Speaker is vacant, the duties of the office shall be performed by the Deputy Speaker or, if the office of Deputy Speaker is also vacant, by such member of the Assembly as the Governor may appoint for the purpose. 2. During the absence of the Speaker from any sitting of the Assembly, the Deputy Speaker or, if he is also absent, such person as may be determined by the rules of procedure of the Assembly, or, if no such person is present, such other person as may be determined by the Assembly, shall act as Speaker. 181. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration. 1. At any sitting of the Legislative Assembly, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of Clause 2 of Article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Speaker or, as the case may be, the Deputy Speaker, is absent. 2. The Speaker shall have the right to speak in, and otherwise to take part in the proceedings of, the Legislative Assembly while any resolution for his removal from office is under consideration in the Assembly and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings but not in the case of an equality of votes. 182. The Chairman and Deputy Chairman of the Legislative Council. The Legislative Council of every state having such council shall, as soon as may be, choose 2 members of the council to be respectively Chairman and Deputy Chairman thereof and, so often as the office of Chairman or Deputy Chairman becomes vacant, the council shall choose another member to be Chairman or Deputy Chairman, as the case may be. 183. Vacation and resignation of, and removal from, the offices of Chairman and Deputy Chairman. A member holding office as Chairman or Deputy Chairman of a Legislative Council 1. Shall vacate his office if he ceases to be a member of the Council. 2. May at any time by writing under his hand addressed, if such member is the Chairman, to the Deputy Chairman, and if such member is the Deputy Chairman, to the Chairman, resign his office and 3. May be removed from his office by a resolution of the Council passed by a majority of all the then members of the Council. Provided that no resolution for the purpose of Clause C shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. 184. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman. 1. While the office of Chairman is vacant, the duties of the office shall be performed by the Deputy Chairman or, if the office of Deputy Chairman is also vacant, by such member of the Council as the Governor may appoint for the purpose. 2. During the absence of the Chairman from any sitting of the Council, the Deputy Chairman or, if he is also absent, such person as may be determined by the rules of procedure of the Council, or, if no such person is present, such other person as may be determined by the Council, shall act as Chairman. 185. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration. 1. At any sitting of the Legislative Council, while any resolution for the removal of the Chairman from his office is under consideration, the Chairman, or while any resolution for the removal of the Deputy Chairman from his office is under consideration, the Deputy Chairman shall not, though he is present, preside, and the provisions of Clause 2 of Article 184 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Chairman or, as the case may be, the Deputy Chairman is absent. 2. The Chairman shall have the right to speak in, and otherwise to take part in the proceedings of, the Legislative Council while any resolution for his removal from office is under consideration in the Council and shall notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings but not in the case of an equality of votes. 186. Salaries and allowances of the Speaker and Deputy Speaker and the Chairman and Deputy Chairman thus shall be paid to the Speaker and the Deputy Speaker of the Legislative Assembly, and to the Chairman and the Deputy Chairman of the Legislative Council, such salaries and allowances as may be respectively fixed by the legislature of the state by law and, until a provision in that behalf is so made, such salaries and allowances as are specified in the second schedule. 187. Secretariat of State Legislature. 1. The House or each House of the Legislature of a state shall have a separate secretarial staff, provided that nothing in this clause shall, in the case of the legislature of a state having a legislative council, be construed as preventing the creation of posts common to both houses of such legislature. 2. The legislature of a state may by law regulate the recruitment, and the conditions of service of persons appointed to the secretarial staff of the House or Houses of the legislature of the state. 2. Until provision is made by the legislature of the state under clause 2, the governor may, after consultation with the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be, make rules regulating the recruitment, and the conditions of service of persons appointed to the secretarial staff of the Assembly or the Council, and any rules so made shall have effect subject to the provisions of any law made under the said clause. Conduct of Business 188. Oath or affirmation by members. Every member of the Legislative Assembly or the Legislative Council of a state shall, before taking his seat, make and subscribe before the governor, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 189. Voting in Houses. Power of Houses to act notwithstanding vacancies and quorum. 1. Save as otherwise provided in this Constitution, all questions at any sitting of a House of the Legislature of a state shall be determined by a majority of votes of the members present and voting, other than the Speaker or Chairman, or person acting as such. The Speaker or Chairman, or person acting as such, shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. 2. A House of the Legislature of a state shall have power to act notwithstanding any vacancy in the membership thereof, and any proceedings in the legislature of a state shall be valid notwithstanding that it is discovered subsequently that some person who was not entitled so to do sat or voted or otherwise took part in the proceedings. 3. Until the legislature of the state by law otherwise provides, the quorum to constitute a meeting of a House of the Legislature of a state shall be 10 members or 1/10 of the total number of members of the House, whichever is greater. 4. If at any time during a meeting of the Legislative Assembly or the Legislative Council of a state there is no quorum, it shall be the duty of the Speaker or Chairman, or person acting as such, either to adjourn the House or to suspend the meeting until there is a quorum. Disqualifications of members. 190. Vacation of seats. 1. No person shall be a member of both houses of the legislature of a state, and provision shall be made by the legislature of the state by law for the vacation by a person who is chosen a member of both houses of his seat in one house or the other. 2. No person shall be a member of the legislatures of 2 or more states specified in the first schedule, and if a person is chosen a member of the legislatures of 2 or more such states, then, at the expiration of such period as may be specified in rules made by the President, that person's seat in the legislatures of all such states shall become vacant, unless he has previously resigned his seat in the legislatures of all but one of the states. 3. If a member of a house of the legislature of a state A sense becomes subject to any of the disqualifications mentioned in Clause 1, or Clause 2, of Article 191, or A sense resigns his seat by writing under his hand addressed to the Speaker or the Chairman, as the case may be, and his resignation is accepted by the Speaker or the Chairman, as the case may be, his seat shall thereupon become vacant. Provided that in the case of any resignation referred to in sub-clause B, if from information received or otherwise and after making such inquiry as he thinks fit, the Speaker or the Chairman, as the case may be, is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. 4. If for a period of 60 days a member of a house of the legislature of a state is without permission of the House absent from all meetings thereof, the House may declare his seat vacant. provided that in computing the said period of 60 days no account shall be taken of any period during which the House is prorogued or is adjourned for more than 4 consecutive days. 191. Disqualifications for membership. 1. A person shall be disqualified for being chosen as, and for being, a member of the Legislative Assembly or Legislative Council of a state. A sense if he holds any office of profit under the Government of India or the Government of any state specified in the first schedule, other than an office declared by the legislature of the state by law not to disqualify its holder. A sense if he is of unsound mind and stands so declared by a competent court. A sense if he is an undischarged insolvent. A sense if he is not a citizen of India, or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgement of allegiance or adherence to a foreign state. A sense if he is so disqualified by or under any law made by Parliament. Explanation for the purposes of this clause. A person shall not be deemed to hold an office of profit under the Government of India or the Government of any state specified in the first schedule by reason only that he is a minister either for the Union or for such state. 2. A person shall be disqualified for being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule. 192. Decision on questions as to disqualifications of members. 1. If any question arises as to whether a member of a house of the legislature of a state has become subject to any of the disqualifications mentioned in Clause 1 of Article 191, the question shall be referred for the decision of the Governor and his decision shall be final. 2. Before giving any decision on any such question, the Governor shall obtain the opinion of the Election Commission and shall act according to such opinion. 193. Penalty for sitting and voting before making oath or affirmation under Article 188 or when not qualified or when disqualified if a person sits or votes as a member of the Legislative Assembly or the Legislative Council of a state before he has complied with the requirements of Article 188, or when he knows that he is not qualified or that he is disqualified for membership thereof, or that he is prohibited from so doing by the provisions of any law made by Parliament or the legislature of the state, he shall be liable in respect of each day on which he so sits or votes to a penalty of 500 rupees to be recovered as a debt due to the state. Powers, privileges and immunities of state legislatures and their members. 194. Powers, privileges, etc., of the houses of legislatures and of the members and committees thereof. 1. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. 2. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of a house of such a legislature of any report, paper, votes or proceedings. 3. In other respects, the powers, privileges and immunities of a house of the legislature of a state, and of the members and the committees of a house of such legislature, shall be such as may from time to time be defined by the legislature by law, and, until so defined, shall be those of that house and of its members and committees immediately before the coming into force of Section 26 of the Constitution, 44th Amendment, Act, 1978. 4. The provisions of clauses 1, 2, and 3, shall apply in relation to persons who by virtue of this Constitution have the right to speak in, and otherwise to take part in the proceedings of, a house of the legislature of a state or any committee thereof as they apply in relation to members of that legislature. 195. Salaries and allowances of members of the Legislative Assembly and the Legislative Council of a state shall be entitled to receive such salaries and allowances as may from time to time be determined, by the legislature of the state by law and, until a provision in that respect is so made, salaries and allowances at such rates and upon such conditions as were immediately before the commencement of this Constitution applicable in the case of members of the Legislative Assembly of the corresponding province. Legislative Procedure 196. Provisions as to introduction and passing of Bills 1. Subject to the provisions of Article 198 and 207 with respect to money bills and other financial bills, a bill may originate in either house of the legislature of a state which has a legislative council. 2. Subject to the provisions of Articles 197 and 198, a bill shall not be deemed to have been passed by the houses of the legislature of a state having a legislative council unless it has been agreed to by both houses, either without amendment or with such amendments only as are agreed to by both houses. 3. A bill pending in the legislature of a state shall not lapse by reason of the prorogation of the house or houses thereof. 4. A bill pending in the Legislative Council of a state which has not been passed by the Legislative Assembly shall not lapse on a dissolution of the Assembly. 5. A bill which is pending in the Legislative Assembly of a state, or which having been passed by the Legislative Assembly is pending in the Legislative Council, shall lapse on a dissolution of the Assembly. 197. Restriction on powers of Legislative Council as to bills other than money bills. 1. If after a bill has been passed by the Legislative Assembly of a state having a Legislative Council and transmitted to the Legislative Council, a. Since the bill is rejected by the Council or a. Since more than 3 months elapse from the date on which the bill is laid before the Council without the bill being passed by it or since the bill is passed by the Council with amendments to which the Legislative Assembly does not agree. The Legislative Assembly may, subject to the rules regulating its procedure, pass the bill again in the same or in any subsequent session with or without such amendments, if any, as have been made, suggested or agreed to by the Legislative Council, and then transmit the bill as so passed to the Legislative Council. 2. If after a bill has been so passed for the second time by the Legislative Assembly and transmitted to the Legislative Council a. Since the bill is rejected by the Council or a. Since more than 1 month elapses from the date on which the bill is laid before the Council without the bill being passed by it or a. Since the bill is passed by the Council with amendments to which the Legislative Assembly does not agree, the bill shall be deemed to have been passed by the houses of the legislature of the state in the form in which it was passed by the Legislative Assembly for the second time with such amendments, if any, as have been made or suggested by the Legislative Council and agreed to by the Legislative Assembly. 3. Nothing in this article shall apply to a money bill. 198. Special procedure in respect of money bills. 1. A money bill shall not be introduced in a legislative council. 2. After a money bill has been passed by the Legislative Assembly of a state having a legislative council, it shall be transmitted to the Legislative Council for its recommendations, and the Legislative Council shall within a period of 14 days from the date of its receipt of the bill return the bill to the Legislative Assembly with its recommendations, and the Legislative Assembly may thereupon either accept or reject all or any of the recommendations of the Legislative Council. 3. If the Legislative Assembly accepts any of the recommendations of the Legislative Council, the money bill shall be deemed to have been passed by both houses with the amendments recommended by the Legislative Council and accepted by the Legislative Assembly. 4. If the Legislative Assembly does not accept any of the recommendations of the Legislative Council, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the Legislative Assembly without any of the amendments recommended by the Legislative Council. 5. If a money bill passed by the Legislative Assembly and transmitted to the Legislative Council for its recommendations is not returned to the Legislative Assembly within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the Legislative Assembly. 199. Definition of money bills. 1. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely: A. Cents the imposition, abolition, remission, alteration or regulation of any tax. A. Cents the regulation of the borrowing of money or the giving of any guarantee by the state, or the amendment of the law with respect to any financial obligations undertaken or to be undertaken by the state. A. Cents the custody of the consolidated fund or the contingency fund of the state, the payment of monies into or the withdrawal of monies from any such fund. I. Cents the appropriation of monies out of the consolidated fund of the state. I. Cents the declaring of any expenditure to be expenditure charged on the consolidated fund of the state, or the increasing of the amount of any such expenditure. A. Cents the receipt of money on account of the consolidated fund of the state or the public account of the state or the custody or issue of such money, or A. Cents any matter incidental to any of the matters specified in subclauses A2, F. 2. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. 3. If any question arises whether a bill introduced in the legislature of a state which has a legislative council is a money bill or not, the decision of the Speaker of the Legislative Assembly of such state thereon shall be final. 4. There shall be endorsed on every money bill when it is transmitted to the Legislative Council under Article 198, and when it is presented to the Governor for assent under Article 200. The certificate of the Speaker of the Legislative Assembly signed by him that it is a money bill. 200. Assent to bills. When a bill has been passed by the Legislative Assembly of a state or, in the case of a state having a legislative council, has been passed by both houses of the legislature of the state, it shall be presented to the Governor and the Governor shall declare either that he assents to the bill or that he withholds assent therefrom or that he reserves the bill for the consideration of the President. Provided that the Governor may, as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill together with a message requesting that the House or Houses will reconsider the bill or any specified provisions thereof and, in particular, will consider the desirability of introducing any such amendments as he may recommend in his message and, when a bill is so returned, the House or Houses shall reconsider the bill accordingly, and if the bill is passed again by the House or Houses with or without amendment and presented to the Governor for assent, the Governor shall not withhold assent therefrom, provided further that the Governor shall not assent to, but shall reserve for the consideration of the President, any bill which in the opinion of the Governor would, if it became law, so derogate from the powers of the High Court as to endanger the position which that court is by this Constitution designed to fill. 201. Bills reserved for consideration. When a bill is reserved by a Governor for the consideration of the President shall declare either that he assents to the bill or that he withholds assent therefrom. Provided that, where the bill is not a money bill, the President may direct the Governor to return the bill to the House or, as the case may be, the Houses of the Legislature of the State together with such a message as is mentioned in the first proviso to Article 200 and, when a bill is so returned, the House or Houses shall reconsider it accordingly within a period of 6 months from the date of receipt of such message and, if it is again passed by the House or Houses with or without amendment, it shall be presented again to the President for his consideration. Procedure in Financial Matters 202. Annual Financial Statement 1. The Governor shall in respect of every financial year cause to be laid before the House or Houses of the Legislature of the State a statement of the estimated receipts and expenditure of the State for that year, in this part referred to as the Annual Financial Statement. 2. The estimates of expenditure embodied in the Annual Financial Statement shall show separately cents the sums required to meet expenditure described by this Constitution as expenditure charged upon the Consolidated Fund of the State and cents the sums required to meet other expenditure proposed to be made from the Consolidated Fund of the State, and shall distinguish expenditure on revenue account from other expenditure. 3. The following expenditure shall be expenditure charged on the Consolidated Fund of each State. Cents the emoluments and allowances of the Governor and other expenditure relating to his office. Cents the salaries and allowances of the Speaker and the Deputy Speaker of the Legislative Assembly and, in the case of State having a Legislative Council, also of the Chairman and the Deputy Chairman of the Legislative Council. Cents debt charges for which the State is liable including interest, sinking fund charges and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt. Cents expenditure in respect of the salaries and allowances of judges of any high court. Cents any sums required to satisfy any judgment, decree or award of any court or arbitral tribunal. Cents any other expenditure declared by this Constitution, or by the legislature of the State by law, to be so charged. 203. Procedure in Legislature with respect to estimates 1. So much of the estimates as relates to expenditure charged upon the Consolidated Fund of a State shall not be submitted to the vote of the Legislative Assembly, but nothing in this clause shall be construed as preventing the discussion in the legislature of any of those estimates. 2. So much of the said estimates as relates to other expenditure shall be submitted in the form of demands for grants to the Legislative Assembly, and the Legislative Assembly shall have power to assent, or to refuse to assent, to any demand, or to assent to any demand subject to a reduction of the amount specified therein. 3. No demand for a grant shall be made except on the recommendation of the Governor. 204. Appropriation Bills. 1. As soon as may be after the grants under Article 203 have been made by the Assembly, there shall be introduced a bill to provide for the appropriation out of the Consolidated Fund of the State of all monies required to meet cents the grants so made by the Assembly and cents the expenditure charged on the Consolidated Fund of the State but not exceeding in any case the amount shown in the statement previously laid before the House or Houses. 2. No amendment shall be proposed to any such bill in the House or either House of the Legislature of the State which will have the effect of varying the amount or altering the destination of any grant so made or of varying the amount of any expenditure charged on the Consolidated Fund of the State, and the decision of the person presiding as to whether an amendment is inadmissible under this clause shall be final. 3. Subject to the provisions of Articles 205 and 206, no money shall be withdrawn from the Consolidated Fund of the State except under appropriation made by law passed in accordance with the provisions of this article. 205. Supplementary, additional or excess grants. 1. The Governor shall cents if the amount authorized by any law made in accordance with the provisions of Article 204 to be expended for a particular service for the current financial year is found to be insufficient for the purposes of that year or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement for that year, or cents if any money has been spent on any service during a financial year in excess of the amount granted for that service and for that year. cause to be laid before the House or the Houses of the Legislature of the state another statement showing the estimated amount of that expenditure or cause to be presented to the Legislative Assembly of the state a demand for such excess, as the case may be. 2. The provisions of Articles 202, 203 and 204 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of the consolidated fund of the state to meet such expenditure or the grant in respect of such demand as they have effect in relation to the annual financial statement and the expenditure mentioned therein, or to a demand for a grant and the law to be made for the authorization of appropriation of monies out of the consolidated fund of the state to meet such expenditure or grant. 206. Votes on account, votes of credit and exceptional grants. 1. Notwithstanding anything in the foregoing provisions of this chapter, the Legislative Assembly of a state shall have power a sense to make any grant in advance in respect of the estimated expenditure for a part of any financial year pending the completion of the procedure prescribed in Article 203 for the voting of such grant and the passing of the law in accordance with the provisions of Article 204 in relation to that expenditure. A sense to make a grant for meeting an unexpected demand upon the resources of the state when on account of the magnitude or the indefinite character of the service the demand cannot be stated with the details ordinarily given in an annual financial statement. A sense to make an exceptional grant which forms no part of the current service of any financial year. And the legislature of the state shall have power to authorize by law the withdrawal of monies from the consolidated fund of the state for the purposes for which the said grants are made. 2. The provisions of Articles 203 and 204 shall have effect in relation to the making of any grant under Clause 1, and to any law to be made under that clause as they have effect in relation to the making of a grant with regard to any expenditure mentioned in the annual financial statement and the law to be made for the authorization of appropriation of monies out of the consolidated fund of the state to meet such expenditure. 207. Special provisions as to financial bills. 1. A bill or amendment making provision for any of the matters specified in sub-clauses A, 2, F, of Clause 1, of Article 199 shall not be introduced or moved except on the recommendation of the Governor, and a bill making such provision shall not be introduced in a legislative council, provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. 2. A bill or amendment shall not be deemed to make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. 3. A bill which, if enacted and brought into operation, would involve expenditure from the consolidated fund of a state shall not be passed by a House of the Legislature of the state unless the Governor has recommended to that House the consideration of the bill. Procedure Generally 208. Rules of Procedure 1. A House of the Legislature of a state may make rules for regulating, subject to the provisions of this Constitution, its procedure and the conduct of its business. 2. Until rules are made under Clause 1, the rules of procedure and standing orders in force immediately before the commencement of this Constitution with respect to the legislature for the corresponding province shall have effect in relation to the legislature of the state subject to such modifications and adaptations as may be made therein by the Speaker of the Legislative Assembly, or the Chairman of the Legislative Council, as the case may be. 3. In a state having a legislative council, the Governor, after consultation with the Speaker of the Legislative Assembly and the Chairman of the Legislative Council, may make rules as to the procedure with respect to communications between the two houses. 209. Regulation by law of procedure in the legislature of the state in relation to financial business. The legislature of a state may, for the purpose of the timely completion of financial business, regulate by law the procedure of, and the conduct of business in, the house or houses of the legislature of the state in relation to any financial matter or to any bill for the appropriation of monies out of the consolidated fund of the state, and, if and so far as any provision of any law so made is inconsistent with any rule made by the House or either House of the legislature of the state under Clause 1 of Article 208 or with any rule or standing order having effect in relation to the legislature of the state under Clause 2 of that article, such provision shall prevail. 210. Language to be used in the legislature. 1. Notwithstanding anything in Part 17, but subject to the provisions of Article 348, business in the legislature of a state shall be transacted in the official language or languages of the state or in Hindi or in English. Provided that the Speaker of the Legislative Assembly or Chairman of the Legislative Council, or person acting as such, as the case may be, may permit any member who cannot adequately express himself in any of the languages aforesaid to address the House in his mother tongue. 2. Unless the legislature of the state by law otherwise provides, this article shall, after the expiration of a period of 15 years from the commencement of this Constitution, have effect as if the words "or" in English were omitted therefrom. Provided that in relation to the legislatures of the states of Himachal Pradesh, Manipur, Meghalaya and Tripura this clause shall have effect as if for the words 15 years occurring therein, the words 25 years were substituted. Provided further that in relation to the legislature of the states of Arunachal Pradesh, Goa and Mizoram, this clause shall have effect as if for the words 15 years occurring therein, the words 40 years were substituted. 211. Restriction on discussion in the legislature. No discussion shall take place in the legislature of a state with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties. 212. Courts not to inquire into proceedings of the legislature. 1. The validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularity or procedure. 2. No officer or member of the legislature of a state in whom powers are vested by or under this Constitution for regulating procedure or the conduct of business, or for maintaining order, in the legislature shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Chapter 4. Legislative power of the Governor. 213. Power of Governor to promulgate ordinances during recess of legislature. 1. If at any time, except when the Legislative Assembly of a state is in session, or where there is a Legislative Council in a state, except when both houses of the legislature are in session, the Governor is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear to him to require. Provided that the Governor shall not, without instructions from the President, promulgate any such ordinance if a sensible containing the same provisions would under this Constitution have required the previous sanction of the President for the introduction thereof into the legislature, or a sense he would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the President, or a sense an act of the legislature of the state containing the same provisions would under this Constitution have been invalid unless, having been reserved for the consideration of the President, it had received the assent of the President. 2. An ordinance promulgated under this article shall have the same force and effect as an act of the legislature of the state assented to by the Governor, but every such ordinance sense shall be laid before the Legislative Assembly of the state, or where there is a Legislative Council in the state, before both the houses, and shall cease to operate at the expiration of 6 weeks from the reassembly of the legislature, or if before the expiration of that period a resolution disapproving it is passed by the Legislative Assembly and agreed to by the Legislative Council, if any, upon the passing of the resolution or, as the case may be, on the resolution being agreed to by the Council and assents may be withdrawn at any time by the Governor. Explanation whether houses of the legislature of a state having a legislative council are summoned to reassemble on different dates, the period of 6 weeks shall be reckoned from the later of those dates for the purposes of this clause. 3. If and so far as an ordinance under this article makes any provision which would not be valid if enacted in an act of the legislature of the state assented to by the Governor, it shall be void. Provided that, for the purposes of the provisions of this Constitution relating to the effect of an act of the legislature of a state which is repugnant to an act of Parliament or an existing law with respect to a matter enumerated in the concurrent list, an ordinance promulgated under this article in pursuance of instructions from the President shall be deemed to be an act of the legislature of the state which has been reserved for the consideration of the President and assented to by him. Chapter 5. The High Courts in the States. 214. High Courts for States. There shall be a High Court for each state. 215. High Courts to be courts of record. Every High Court shall be a court of record and shall have all the powers of such a court including the power to punish for contempt of itself. 216. Constitution of High Courts. Every High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary to appoint. 217. Appointment and conditions of the office of a judge of a High Court. 1. Every judge of a High Court shall be appointed by the President by warrant under his hand and seal on the recommendation of the National Judicial Appointments Commission referred to in Article 124A, and shall hold office, in the case of an additional or acting judge, as provided in Article 224, and in any other case, until he attains the age of 62 years. Provided that assents a judge may, by writing under his hand addressed to the President, resign his office. Assents a judge may be removed from his office by the President in the manner provided in Clause 4 of Article 124 for the removal of a judge of the Supreme Court. Assents the office of a judge shall be vacated by his being appointed by the President to be a judge of the Supreme Court or by his being transferred by the President to any other High Court within the territory of India. 2. A person shall not be qualified for appointment as a judge of a High Court unless he is a citizen of India and assents has for at least 10 years held a judicial office in the territory of India or assents has for at least 10 years been an advocate of a High Court or of 2 or more such courts in succession. Explanation. For the purposes of this clause, assents in computing the period during which a person has held a judicial office in the territory of India, there shall be included any period, after he has held any judicial office, during which the person has been an advocate of a High Court or has held the office of a member of a tribunal or any post, under the Union or a state, requiring special knowledge of law. Assents in computing the period during which a person has been an advocate of a High Court, there shall be included any period during which the person has held a judicial office or the office of a member of a tribunal or any post, under the Union or a state, requiring special knowledge of law after he became an advocate. Assents in computing the period during which a person has held a judicial office in the territory of India or been an advocate of a High Court, there shall be included any period before the commencement of this Constitution during which he has held a judicial office in any area which was comprised before the 15th day of August, 1947, within India as defined by the Government of India Act, 1935, or has been an advocate of any High Court in any such area, as the case may be. 3. If any question arises as to the age of a judge of a High Court, the question shall be decided by the President after consultation with the Chief Justice of India and the decision of the President shall be final. 218. Application of certain provisions relating to Supreme Court to High Courts. The provisions of clauses 4 and 5 of Article 124 shall apply in relation to a High Court as they apply in relation to the Supreme Court, with the substitution of references to the High Court for references to the Supreme Court. 219. Oath or affirmation by judges of High Courts. Every person appointed to be a judge of a High Court shall, before he enters upon his office, make and subscribe before the Governor of the State, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 220. Restriction on practice after being a permanent judge. No person who, after the commencement of this Constitution, has held office as a permanent judge of a High Court shall plead or act in any court or before any authority in India except the Supreme Court and the other High Courts. Explanation in this article. The expression High Court does not include a High Court for a state specified in Part B of the first schedule as it existed before the commencement of the Constitution, 7th Amendment, Act, 1956. 221. Salaries, etc., of judges. 1. There shall be paid to the judges of each High Court such salaries as may be determined by Parliament by law and, until a provision in that behalf is so made, such salaries as are specified in the second schedule. 2. Every judge shall be entitled to such allowances and to such rights in respect of leave of absence and pension as may from time to time be determined by or under law made by Parliament and, until so determined, to such allowances and rights as are specified in the second schedule. Provided that neither the allowances of a judge nor his rights in respect of leave of absence or pension shall be varied to his disadvantage after his appointment. 222. Transfer of a judge from one High Court to another. 1. The President may, on the recommendation of the National Judicial Appointments Commission referred to in Article 124A, transfer a judge from one High Court to any other High Court. 2. When a judge has been or is so transferred, he shall, during the period he serves, after the commencement of the Constitution, 15th Amendment, Act, 1963, as a judge of the other High Court, be entitled to receive in addition to his salary such compensatory allowance as may be determined by Parliament by law and, until so determined, such compensatory allowance as the President may by order fix. 223. Appointment of acting Chief Justice. When the office of Chief Justice of a High Court is vacant or when any such Chief Justice is by reason of absence or otherwise, unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purpose. 224. Appointment of additional and acting judges. 1. If by reason of any temporary increase in the business of a High Court or by reason of arrears of work therein, it appears to the President that the number of the judges of that court should be for the time being increased, the President may, in consultation with the National Judicial Appointments Commission, appoint duly qualified persons to be additional judges of the court for such period not exceeding 2 years as he may specify. 2. When any judge of a High Court other than the Chief Justice is by reason of absence or for any other reason unable to perform the duties of his office or is appointed to act temporarily as Chief Justice, the President may, in consultation with the National Judicial Appointments Commission, appoint a duly qualified person to act as a judge of that court until the permanent judge has resumed his duties. 3. No person appointed as an additional or acting judge of a High Court shall hold office after attaining the age of 62 years. 224A. Appointment of retired judges at sittings of High Courts. Notwithstanding anything in this chapter, the National Judicial Appointments Commission on a reference made to it by the Chief Justice of a High Court for any state, may with the previous consent of the President, request any person who has held the office of a judge of that court or of any other high court to sit and act as a judge of the high court for that state, and every such person so requested shall, while so sitting and acting, be entitled to such allowances as the President may by order determine, and have all the jurisdiction, powers and privileges of, but shall not otherwise be deemed to be, a judge of that high court. Provided that nothing in this article shall be deemed to require any such person as aforesaid to sit and act as a judge of that high court unless he consents so to do. 225. Jurisdiction of existing high courts. Subject to the provisions of this Constitution and to the provisions of any law of the appropriate legislature made by virtue of powers conferred on that legislature by this Constitution, the jurisdiction of, and the law administered in, any existing high court, and the respective powers of the judges thereof in relation to the administration of justice in the court, including any power to make rules of court and to regulate the sittings of the court and of members thereof sitting alone or in division courts, shall be the same as immediately before the commencement of this Constitution. Provided that any restriction to which the exercise of original jurisdiction by any of the high courts with respect to any matter concerning the revenue or concerning any act ordered or done in the collection thereof was subject immediately before the commencement of this Constitution shall no longer apply to the exercise of such jurisdiction. 226. Power of high courts to issue certain writs. 1. Notwithstanding anything in Article 32, every high court shall have power, throughout the territories in relation to which it exercises jurisdiction, to issue to any person or authority, including in appropriate cases, any government, within those territories directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them, for the enforcement of any of the rights conferred by Part 3 and for any other purpose. 2. The power conferred by Clause 1, to issue directions, orders or writs to any government, authority or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action, wholly or in part, arises for the exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. 3. Where any party against whom an interim order, whether by way of injunction or stay or in any other manner, is made on, or in any proceedings relating to, a petition under Clause 1, without assents furnishing to such party copies of such petition and all documents in support of the plea for such interim order and assents giving such party an opportunity of being heard, makes an application to the High Court for the vacation of such order and furnishes a copy of such application to the party in whose favor such order has been made or the counsel of such party, the High Court shall dispose of the application within a period of 2 weeks from the date on which it is received or from the date on which the copy of such application is so furnished, whichever is later, or where the High Court is closed on the last day of that period, before the expiry of the next day afterwards on which the High Court is open, and if the application is not so disposed of, the interim order shall, on the expiry of that period, or, as the case may be, the expiry of the said next day, stand vacated. 4. The power conferred on a high court by this article shall not be in derogation of the power conferred on the Supreme Court by Clause 2, of Article 32. 226a. Constitutional validity of central laws not to be considered in proceedings under Article 226 Rep. By the Constitution, 43rd Amendment, Act, 1977, S.8, WEF 13 April 1978. 227. Power of superintendence over all courts by the High Court. 1. Every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. 2. Without prejudice to the generality of the foregoing provision, the High Court may call for returns from such courts, make and issue general rules and prescribe forms for regulating the practice and proceedings of such courts, and prescribe forms in which books, entries and accounts shall be kept by the officers of any such courts. 3. The High Court may also settle tables of fees to be allowed to the sheriff and all clerks and officers of such courts and to attorneys, advocates and pleaders practicing therein. Provided that any rules made, forms prescribed or tables settled under Clause 2, or Clause 4, shall not be inconsistent with the provision of any law for the time being in force, and shall require the previous approval of the Governor. 5. Nothing in this article shall be deemed to confer on a High Court powers of superintendence over any court or tribunal constituted by or under any law relating to the armed forces. 228. Transfer of certain cases to High Court. If the High Court is satisfied that a case pending in a court subordinate to it involves a substantial question of law as to the interpretation of this Constitution, the determination of which is necessary for the disposal of the case, it shall withdraw the case and may 1. Either dispose of the case itself, or 2. Determine the said question of law and return the case to the court from which the case has been so withdrawn, together with a copy of its judgment on such question, and the said court shall on receipt thereof proceed to dispose of the case in conformity with such judgment. 228a. Special provisions as to disposal of questions relating to constitutional validity of state laws. Rep. By the Constitution, 43rd Amendment, Act, 1977, S. 10, WEF 13 April 1978. 229. Officers and servants and the expenses of High Courts. 1. Appointments of officers and servants of the High Court shall be made by the Chief Justice of the Court or such other judge or officer of the court as he may direct, provided that the Governor of the State may by rule require that in such cases as may be specified in the rule no person not already attached to the court shall be appointed to any office connected with the court save after consultation with the State Public Service Commission. 2. Subject to the provisions of any law made by the legislature of the state, the conditions of service of officers and servants of a High Court shall be such as may be prescribed by rules made by the Chief Justice of the Court or by some other judge or officer of the court authorized by the Chief Justice to make rules for the purpose. Provided that the rules made under this clause shall, so far as they relate to salaries, allowances, leave or pensions, require the approval of the Governor of the State. 3. The administrative expenses of a High Court, including all salaries, allowances and pensions payable to or in respect of the officers and servants of the court, shall be charged upon the consolidated fund of the state, and any fees or other monies taken by the court shall form part of that fund. 230. Extension of jurisdiction of High Courts to Union Territories. 1. Parliament may by law extend the jurisdiction of a High Court to, or exclude the jurisdiction of a High Court from, any Union Territory. 2. Where the High Court of a state exercises jurisdiction in relation to a Union Territory, since nothing in this Constitution shall be construed as empowering the legislature of the state to increase, restrict or abolish that jurisdiction, and since the reference in Article 227 to the Governor shall, in relation to any rules, forms or tables for subordinate courts in that territory, be construed as a reference to the President. 231. Establishment of a common High Court for 2 or more states. 1. Notwithstanding anything contained in the preceding provisions of this chapter, Parliament may by law establish a common High Court for 2 or more states or for 2 or more states and a Union Territory. 2. In relation to any such High Court, a sentence, omitted by the Constitution, 99th Amendment, Act, 2014. A. Since the reference in Article 227 to the Governor shall, in relation to any rules, forms or tables for subordinate courts, be construed as a reference to the Governor of the state in which the subordinate courts are situate and A. Since the references in Articles 219 and 229 to the state shall be construed as a reference to the state in which the High Court has its principal seat. Provided that if such principal seat is in a Union territory, the references in Articles 219 and 229 to the Governor, Public Service Commission, Legislature and Consolidated Fund of the state shall be construed respectively as references to the President, Union Public Service Commission, Parliament and Consolidated Fund of India. Chapter 6. Subordinate Courts 233. Appointment of District Judges 1. Appointments of persons to be, and the posting and promotion of, district judges in any state shall be made by the Governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. 2. A person not already in the service of the Union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. 233a. Validation of appointments of, and judgments, etc., delivered by, certain district judges. Notwithstanding any judgment, decree or order of any court, 1. A. Since no appointment of any person already in the judicial service of a state or of any person who has been for not less than 7 years an advocate or a pleader, to be a district judge in that state, and A. Since no posting, promotion or transfer of any such person as a district judge, made at any time before the commencement of the Constitution, 20th Amendment, Act, 1966, otherwise than in accordance with the provisions of Article 233 or Article 235 shall be deemed to be illegal or void or ever to have become illegal or void by reason only of the fact that such appointment, posting, promotion or transfer was not made in accordance with the said provisions. 2. No jurisdiction exercised, no judgment, decree, sentence or order passed or made, and no other act or proceeding done or taken before the commencement of the Constitution, 20th Amendment, Act, 1966 by, or before, any person appointed, posted, promoted or transferred as a district judge in any state otherwise than in accordance with the provisions of Article 233 or Article 235 shall be deemed to be illegal or invalid or ever to have become illegal or invalid by reason only of the fact that such appointment, posting, promotion or transfer was not made in accordance with the said provisions. 234. Recruitment of persons other than district judges to the judicial service. Appointments of persons other than district judges to the judicial service of a state shall be made by the Governor of the state in accordance with rules made by him in that behalf after consultation with the State Public Service Commission and with the High Court exercising jurisdiction in relation to such state. 235. Control over subordinate courts. The control over district courts and courts subordinate thereto, including the posting and promotion of, and the grant of leave to, persons belonging to the judicial service of a state and holding any post inferior to the post of district judge shall be vested in the High Court, but nothing in this article shall be construed as taking away from any such person any right of appeal which he may have under the law regulating the conditions of his service or as authorizing the High Court to deal with him otherwise than in accordance with the conditions of his service prescribed under such law. 236. Interpretation. In this chapter. 1. The expression district judge includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, Additional Sessions Judge and Assistant Sessions Judge. 2. The expression judicial service means a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. 237. Application of the provisions of this chapter to certain class or classes of magistrates. The governor may by public notification direct that the foregoing provisions of this chapter and any rules made thereunder shall with effect from such date as may be fixed by him in that behalf apply in relation to any class or classes of magistrates in the state as they apply in relation to persons appointed to the judicial service of the state, subject to such exceptions and modifications as may be specified in the notification. Part 7. The states in Part B of the First Schedule Rep. By the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. Part 8. The Union Territories 239. Administration of Union Territories 1. Save as otherwise provided by Parliament by law, every Union Territory shall be administered by the President acting, to such extent as he thinks fit, through an administrator to be appointed by him with such designation as he may specify. 2. Notwithstanding anything contained in Part 6, the President may appoint the Governor of a state as the administrator of an adjoining Union Territory, and where a Governor is so appointed, he shall exercise his functions as such administrator independently of his Council of Ministers. 239a. Creation of local legislatures or Council of Ministers or both for certain Union Territories. 1. Parliament may by law create for the Union Territory of Pondicherry a censor body, whether elected or partly nominated and partly elected, to function as a legislature for the Union Territory, or a Council of Ministers, or both with such constitution, powers and functions, in each case, as may be specified in the law. 2. Any such law as is referred to in Clause 1, shall not be deemed to be an amendment of this Constitution for the purposes of Article 368, notwithstanding that it contains any provision which amends or has the effect of amending this Constitution. 239r. Special provisions with respect to Delhi. 1. As from the date of commencement of the Constitution, 69th Amendment, Act, 1991, the Union Territory of Delhi shall be called the National Capital Territory of Delhi, hereafter in this part referred to as the National Capital Territory, and the administrator thereof appointed under Article 239 shall be designated as the Lieutenant Governor. 2a. Since there shall be a legislative assembly for the National Capital Territory and the seats in such assembly shall be filled by members chosen by direct election from territorial constituencies in the National Capital Territory. A. Since the total number of seats in the Legislative Assembly, the number of seats reserved for scheduled castes, the division of the National Capital Territory into territorial constituencies, including the basis for such division, and all other matters relating to the functioning of the Legislative Assembly shall be regulated by law made by Parliament. A. Since the provisions of Articles 324 to 327 and 329 shall apply in relation to the National Capital Territory, the Legislative Assembly of the National Capital Territory and the members thereof as they apply, in relation to a state, the Legislative Assembly of a state and the members thereof respectively, and any reference in Articles 326 and 329 to appropriate legislature shall be deemed to be a reference to Parliament. 3a. Since subject to the provisions of this Constitution, the Legislative Assembly shall have power to make laws for the whole or any part of the National Capital Territory with respect to any of the matters enumerated in the State List or in the concurrent list insofar as any such matter is applicable to Union Territories except matters with respect to entries 1, 2 and 18 of the State List and entries 64, 65 and 66 of that list insofar as they relate to the said entries 1, 2, and 18. A. Since nothing in subclause A shall derogate from the powers of Parliament under this Constitution to make laws with respect to any matter for a Union territory or any part thereof. Since if any provision of the law made by the Legislative Assembly with respect to any matter is repugnant to any provision of a law made by Parliament with respect to that matter, whether passed before or after the law made by the Legislative Assembly, or of an earlier law, other than a law made by the Legislative Assembly, then, in either case, the law made by Parliament, or, as the case may be, such earlier law, shall prevail, and the law made by the Legislative Assembly shall, to the extent of the repugnancy, be void. Provided that if any such law made by the Legislative Assembly has been reserved for the consideration of the President and has received his assent, such law shall prevail in the National Capital Territory. Provided further that nothing in this sub-clause shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying or repealing the law so made by the Legislative Assembly. 2. There shall be a Council of Ministers consisting of not more than 10% of the total number of members in the Legislative Assembly, with the Chief Minister at the head to aid and advise the Lieutenant Governor in the exercise of his functions in relation to matters with respect to which the Legislative Assembly has power to make laws, except in so far as he is, by or under any law, required to act in his discretion. Provided that in the case of difference of opinion between the Lieutenant Governor and his ministers on any matter, the Lieutenant Governor shall refer it to the President for decision and act according to the decision given thereon by the President, and pending such decision it shall be competent for the Lieutenant Governor in any case where the matter, in his opinion, is so urgent that it is necessary for him to take immediate action, to take such action or to give such direction in the matter as he deems necessary. 3. The Chief Minister shall be appointed by the President, and the other ministers shall be appointed by the President on the advice of the Chief Minister, and the ministers shall hold office during the pleasure of the President. 4. The Council of Ministers shall be collectively responsible to the Legislative Assembly. 7. Since Parliament may, by law, make provisions for giving effect to, or supplementing the provisions contained in the foregoing clauses, and for all matters incidental or consequential thereto. Since any such law as is referred to in sub-clause A, shall not be deemed to be an amendment of this Constitution for the purposes of Article 368, notwithstanding that it contains any provision which amends or has the effect of amending this Constitution. 5. The provisions of Article 239b shall, so far as may be, apply in relation to the National Capital Territory, the Lieutenant Governor and the Legislative Assembly, as they apply in relation to the Union Territory of Pondicherry, the Administrator and its Legislature, respectively, and any reference in that article to Clause 1 of Article 239a shall be deemed to be a reference to this article or Article 239 ab, as the case may be. 239 ab. Provisions in case of failure of constitutional machinery. If the President, on receipt of report from the Lieutenant Governor or otherwise, is satisfied 1. That a situation has arisen in which the administration of the National Capital Territory cannot be carried on in accordance with the provisions of Article 239 or of any law made in pursuance of that article, or 2. That for the proper administration of the National Capital Territory it is necessary or expedient so to do. The President may by order suspend the operation of any provision of Article 239 or of all or any of the provisions of any law made in pursuance of that article for such period and subject to such conditions as may be specified in such law, and make such incidental and consequential provisions as may appear to him to be necessary or expedient for administering the National Capital Territory in accordance with the provisions of Article 239 and Article 239r. 239b. Power of Administrator to promulgate ordinances during recess of legislature. 1. If at any time, except when the legislature of the Union Territory of Pondicherry is in session. The administrator thereof is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinances as the circumstances appear to him to require, provided that no such ordinance shall be promulgated by the administrator except after obtaining instructions from the President in that behalf. Provided further that whenever the said legislature is dissolved, or its functioning remains suspended on account of any action taken under any such law as is referred to in Clause 1 of Article 239a, the administrator shall not promulgate any ordinance during the period of such dissolution or suspension. 2. An ordinance promulgated under this article in pursuance of instructions from the President shall be deemed to be an act of the legislature of the Union Territory which has been duly enacted after complying with the provisions in that behalf contained in any such law as is referred to in Clause 1 of Article 239a, but every such ordinance shall be laid before the legislature of the Union Territory and shall cease to operate at the expiration of 6 weeks from the reassembly of the legislature, or if, before the expiration of that period, a resolution disapproving it is passed by the legislature, upon the passing of the resolution and assents may be withdrawn at any time by the administrator after obtaining instructions from the President in that behalf. 3. If and so far as an ordinance under this article makes any provision which would not be valid if enacted in an act of the legislature of the Union Territory made after complying with the provisions in that behalf contained in any such law as is referred to in Clause 1 of Article 239a, it shall be void. 240. Power of President to make regulations for certain Union Territories. 1. The President may make regulations for the peace, progress and good government of the Union Territory of A. the Andaman and Nicobar Islands, A. Lakshadweep, I. Dadra and Nagar Haveli, A. Daman Indu, I. Pondicherry. Provided that when any body is created under Article 239a to function as a legislature for the Union Territory of Pondicherry, the President shall not make any regulation for the peace, progress and good government of that Union Territory with effect from the date appointed for the first meeting of the legislature. Provided further that whenever the body functioning as legislature for the Union Territory of Pondicherry is dissolved, or the functioning of that body as such legislature remains suspended on account of any action taken under any such law is referred to in Clause 1 of Article 239a, the President may, during the period of such dissolution or suspension, make regulations for the peace, progress and good government of that Union Territory. 2. Any regulation so made may repeal or amend any act made by Parliament or any other law, which is for the time being applicable to the Union Territory and, when promulgated by the President, shall have the same force and effect as an Act of Parliament which applies to that territory. 241. High Courts for Union Territories. 1. Parliament may by law constitute a High Court for a Union Territory or declare any court in any such territory to be a High Court for all or any of the purposes of this Constitution. 2. The provisions of Chapter 5 of Part 6 shall apply in relation to every High Court referred to in Clause 1, as they apply in relation to a High Court referred to in Article 214, subject to such modifications or exceptions as Parliament may by law provide. 3. Subject to the provisions of this Constitution and to the provisions of any law of the appropriate legislature made by virtue of powers conferred on that legislature by or under this Constitution, every High Court exercising jurisdiction immediately before the commencement of the Constitution, 7th Amendment, Act, 1956, in relation to any Union Territory shall continue to exercise such jurisdiction in relation to that territory after such commencement. 4. Nothing in this article derogates from the power of Parliament to extend or exclude the jurisdiction of a High Court for a state to, or from, any Union territory or part thereof. 242. Cor. Grep. By the Constitution, 7th Amendment, Act, 1956, S. 29 and SCH. Part 9. The Panche at 243. Definitions. In this part, unless the context otherwise requires comma. 1. District means a district in a state. 2. Gram Sabha means a body consisting of persons registered in the electoral rolls relating to a village comprised within the area of Panche at the village level. 3. Intermediate level means a level between the village and district levels specified by the governor of a state by public notification to be the intermediate level for the purposes of this part. 4. Panche at means an institution, by whatever name called, of self-government constituted under Article 243b, for the rural areas. 5. Panche at area means the territorial area of a Panche at. 6. Population means the population as ascertained at the last preceding census of which the relevant figures have been published. 7. Village means a village specified by the governor by public notification to be a village for the purposes of this part and includes a group of villages so specified. 243a. Gram Sabha. A Gram Sabha may exercise such powers and perform such functions at the village level as the legislature of a state may, by law, provide. 243b. Constitution of Panche Ats 1. There shall be constituted in every state, Panche Ats at the village, intermediate and district levels in accordance with the provisions of this part. 2. Notwithstanding anything in clause 1, Panche Ats at the intermediate level may not be constituted in a state having a population not exceeding 20 lakhs. 243c. Composition of Panche Ats. 1. Subject to the provisions of this part, the legislature of a state may, by law, make provisions with respect to the composition of Panche Ats, provided that the ratio between the population of the territorial area of a Panche at any level and the number of seats in such Panche at to be filled by election shall, so far as practicable, be the same throughout the state. 2. All the seats in a Panche at shall be filled by persons chosen by direct election from territorial constituencies in the Panche at area and, for this purpose each Panche at area shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as practicable, be the same throughout the Panche at area. 3. The legislature of a state may, by law, provide for the representation. A sense of the chairpersons of the Panche ats at the village level, in the Panche ats at the intermediate level or, in the case of a state not having Panche ats at the intermediate level, in the Panche ats at the district level. A sense of the chairpersons of the Panche ats at the intermediate level, in the Panche ats at the district level. A sense of the members of the House of the People and the members of the Legislative Assembly of the state representing constituencies which comprise wholly or partly a Panche at area at a level other than the village level, in such Panche at. A sense of the members of the Council of States and the members of the Legislative Council of the state, where they are registered as electors within. A sense of Panche at area at the intermediate level, in Panche at the intermediate level. A sense of Panche at area at the district level, in Panche at the district level. 4. The chairperson of a Panche at and other members of a Panche at whether raw or not chosen by direct election from territorial constituencies in the Panche at area shall have the right to vote in the meetings of the Panche ats. 5. The chairperson of a sense panche at the village level shall be elected in such manner as the legislature of a state may, by law, provide, and a sense panche at the intermediate level or district level shall be elected by, and from amongst, the elected members thereof. 243d. Reservation of seats 1. Seats shall be reserved for a sense the scheduled castes and a sense the scheduled tribes, in every panche and the number of seats so reserved shall bear, as nearly as may be, the same proportion to the total number of seats to be filled by direct election in that panche as the population of the scheduled castes in that panche area or of the scheduled tribes in that panche area bears to the total population of that area, and such seats may be allotted by rotation to different constituencies in a panche. 2. Not less than 1/3 of the total number of seats reserved under Clause 1 shall be reserved for women belonging to the scheduled castes or, as the case may be, the scheduled tribes. 3. Not less than 1/3, including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes, of the total number of seats to be filled by direct election in every panche shall be reserved for women, and such seats may be allotted by rotation to different constituencies in a panche. 4. The offices of the chairpersons in the panche at the village or any other level shall be reserved for the scheduled castes, the scheduled tribes and women in such manner as the legislature of a state may, by law, provide. Provided that the number of offices of chairpersons reserved for the scheduled castes and the scheduled tribes in the panche at each level in any state shall bear, as nearly as may be, the same proportion to the total number of such offices in the panche at each level as the population of the scheduled castes in the state or of the scheduled tribes in the state bears to the total population of the state. Provided further that not less than 1/3 of the total number of offices of chairpersons in the panche at each level shall be reserved for women. Provided also that the number of offices reserved under this clause shall be allotted by rotation to different panche at each level. 5. The reservation of seats under clauses 1 and 2, and the reservation of offices of chairpersons other than the reservation for women, under clause 4, shall cease to have effect on the expiration of the period specified in Article 334. 6. Nothing in this part shall prevent the legislature of a state from making any provision for reservation of seats in any panche or offices of chairpersons in the panche at any level in favor of backward class of citizens. 243e. Duration of panche etc. 1. Every panche unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting and no longer. 2. No amendment of any law for the time being in force shall have the effect of causing dissolution of a panche at any level, which is functioning immediately before such amendment, till the expiration of its duration specified in Clause 1. 3. An election to constitute a panche shall be completed a sense before the expiry of its duration specified in Clause 1, a sense before the expiration of a period of 6 months from the date of its dissolution, provided that where the remainder of the period for which the dissolved panche would have continued is less than 6 months, it shall not be necessary to hold any election under this clause for constituting the panche for such period. 4. A panche constituted upon the dissolution of a panche before the expiration of its duration shall continue only for the remainder of the period for which the dissolved panche would have continued under Clause 1, had it not been so dissolved. 243f. Disqualifications for membership. 1. A person shall be disqualified for being chosen as, and for being, a member of a panche a sense if he is so disqualified by or under any law for the time being in force for the purposes of elections to the legislature of the state concerned. provided that no person shall be disqualified on the ground that he is less than 25 years of age, if he has attained the age of 21 years. A cents if he is so disqualified by or under any law made by the legislature of the state. 2. If any question arises as to whether a member of a Panchayat has become subject to any of the disqualifications mentioned in Clause 1, the question shall be referred for the decision of such authority and in such manner as the legislature of a state may, by law, provide. 243g. Powers, authority and responsibilities of Panchayat. Subject to the provisions of the Constitution, the legislature of a state may, by law, endow the Panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government, and such law may contain provisions for the devolution of powers and responsibilities upon Panchayats at the appropriate level, subject to such conditions as may be specified therein, with respect to 1. The preparation of plans for economic development and social justice. 2. The implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the matters listed in the 11th Schedule. 243h. Powers to impose taxes by, and funds of, the Panchayats. The legislature of a state may, by law, 1. Authorize a Panchayat to levy, collect and appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. 2. Assign to a Panchayat such taxes, duties, tolls and fees levied and collected by the state government for such purposes and subject to such conditions and limits. 3. Provide for making such grants in aid to the Panchayats from the consolidated fund of the state and 4. Provide for constitution of such funds for crediting all monies received, respectively, by or on behalf of the Panchayats and also for the withdrawal of such monies therefrom, as may be specified in the law. 243i. Constitution of Finance Commission to review financial position. 1. The governor of a state shall, as soon as may be within 1 year from the commencement of the Constitution, 73rd Amendment, Act, 1992, and thereafter at the expiration of every 5th year, constitute a Finance Commission to review the financial position of the Panchayats and to make recommendations to the governor as to a. Sense the principles which should govern. I. Sense the distribution between the state and the Panchayats of the net proceeds of the taxes, duties, tolls and fees leviable by the state, which may be divided between them under this part and the allocation between the Panchayats at all levels of their respective shares of such proceeds. A. Sense the determination of the taxes, duties, tolls and fees which may be assigned to, or appropriated by, the Panchayats. A. Sense the grants in aid to the Panchayats from the consolidated fund of the state. A. Sense the measures needed to improve the financial position of the Panchayats. A. Sense any other matter referred to the Finance Commission by the governor in the interests of sound finance of the Panchayats. 2. The legislature of a state may, by law, provide for the composition of the commission, the qualifications which shall be requisite for appointment as members thereof and the manner in which they shall be selected. 3. The Commission shall determine their procedure and shall have such powers in the performance of their functions as the legislature of the state may, by law, confer on them. 4. The Governor shall cause every recommendation made by the Commission under this article together with as explanatory memorandum as to the action taken thereon to be laid before the legislature of the state. 243 Joules. Audit of accounts of Panchayats. The legislature of a state may, by law, make provisions with respect to the maintenance of accounts by the Panchayats and the auditing of such accounts. 243k. Elections to the Panchayats. 1. The superintendence, direction and control of the preparation of electoral rolls for, and the conduct of, All elections to the panchayats shall be vested in a state election commission consisting of a state election commissioner to be appointed by the governor. 2. Subject to the provisions of any law made by the legislature of a state, the conditions of service and tenure of office of the state election commissioner shall be such as the governor may by rule determine, provided that the state election commissioner shall not be removed from his office except in like manner and on the like grounds as a judge of a high court, and the conditions of service of the state election commissioner shall not be varied to his disadvantage after his appointment. 3. The governor of a state shall, when so requested by the State Election Commission, make available to the State Election Commission such staff as may be necessary for the discharge of the functions conferred on the State Election Commission by Clause 1. 4. Subject to the provisions of this Constitution, the legislature of a state may, by law, make provision with respect to all matters relating to, or in connection with, elections to the panchayats. 243 liters. Application to Union Territories. The provisions of this part shall apply to the Union Territories and shall, in their application to a Union Territory, have effect as if the references to the governor of a state were reference to the administrator of the Union Territory appointed under Article 239 and references to the legislature or the legislative assembly of a state were references, in relation to a Union Territory having a legislative assembly, to that legislative assembly. Provided that the President may, by public notification, direct that the provisions of this part shall apply to any Union Territory or part thereof subject to such exceptions and modifications as he may specify in the notification. 243 M. Part not to apply to certain areas. 1. Nothing in this part shall apply to the scheduled areas referred to in Clause 1, and the tribal areas referred to in Clause 2, of Article 244. 2. Nothing in this part shall apply to assents the states of Nagaland, Meghalaya and Mizoram, since the hill areas in the state of Manipur for which district councils exist under any law for the time being in force. 3. Nothing in this part sense relating to panchayats at the district level shall apply to the hill areas of the district of Darjeeling in the state of West Bengal for which Darjeeling Gorkha Hill Council exists under any law for the time being in force. Sense shall be construed to affect the functions and powers of the Darjeeling Gorkha Hill Council constituted under such law. 4. Nothing in Article 243d, relating to reservation of seats for the scheduled castes, shall apply to the state of Arunachal Pradesh. 5. Notwithstanding anything in this Constitution, since the legislature of a state referred to in sub-clause A of Clause 2 may, by law, extend this part to that state, except the areas, if any, referred to in Clause 1, if the Legislative Assembly of that state passes a resolution to that effect by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting. Since Parliament may, by law, extend the provisions of this part to the scheduled areas and the tribal areas referred to in Clause 1, subject to such exceptions and modifications as may be specified in such law, and no such law shall be deemed to be an amendment of this Constitution for the purposes of Article 368. 243 Newtons. Continuance of existing laws and panchayats. Notwithstanding anything in this part, any provision of any law relating to panchayats in force in a state immediately before the commencement of the Constitution, 73rd Amendment, Act, 1992, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed by a competent legislature or other competent authority, or until the expiration of 1 year from such commencement, whichever is earlier. Provided that all the panchayats existing immediately before such commencement shall continue till the expiration of their duration, unless sooner dissolved by a resolution passed to that effect by the Legislative Assembly of that state or, in the case of a state having a legislative council, by each house of the legislature of that state. 243-0. Bar to interference by courts in electoral matters. Notwithstanding anything in this Constitution, 1. The validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies, made or purporting to be made under Article 243k, shall not be called in question in any court. 2. No election to any panchayat shall be called in question except by an election petition presented to such authority and in such manner as is provided for by or under any law made by the legislature of a state. Part X are the municipalities. 243p. Definitions. In this part, unless the context otherwise requires, 1. Committee means a committee constituted under Article 243s. 2. District means a district in a state. 3. Metropolitan area means an area having a population of 10 lakhs or more, comprised in one or more districts and consisting of 2 or more municipalities or panchayats or other contiguous areas, specified by the governor by public notification to be a metropolitan area for the purposes of this part. 4. Municipal area means the territorial area of a municipality as is notified by the governor. 5. Municipality means an institution of self-government constituted under Article 243q. 6. Panchayat means a panchayat constituted under Article 243b. 7. Population means the population as ascertained at the last preceding census of which the relevant figures have been published. 243q. Constitution of municipalities. 1. There shall be constituted in every state, a Sensa Nagar Panchayat, by whatever name called, for transitional area, that is to say, an area in transition from a rural area to an urban area. A Sensa Municipal Council for a smaller urban area and a Sensa Municipal Corporation for a larger urban area. In accordance with the provisions of this part, provided that a municipality under this clause may not be constituted in such urban area or part thereof as the governor may, having regard to the size of the area and the municipal services being provided or proposed to be provided by an industrial establishment in that area and such other factors as he may deem fit, by public notification, specify to be an industrial township. 2. In this article, a transitional area, a smaller urban area or a larger urban area means such area as the governor may, having regard to the population of the area, the density of the population therein, the revenue generated for local administration, the percentage of employment in non-agricultural activities, the economic importance or such other factors as he may deem fit, specify by public notification for the purposes of this part. 243r. Composition of municipalities. 1. Save as provided in Clause 2, all the seats in a municipality shall be filled by persons chosen by direct election from the territorial constituencies in the municipal area, and for this purpose each municipal area shall be divided into territorial constituencies to be known as wards. 2. The legislature of a state may, by law, provide a sense for the representation in a municipality of a sense persons having special knowledge or experience in municipal administration. A sense the members of the House of the People and the members of the Legislative Assembly of the state representing constituencies which comprise wholly or partly the municipal area. A sense the members of the Council of States and the members of the Legislative Council of the state registered as electors within the municipal area. A sense the chairpersons of the committees constituted under Clause 5 of Article 243s. Provided that the persons referred to in paragraph I shall not have the right to vote in the meetings of the municipality. A. Since the manner of election of the chairperson of a municipality. 243s. Constitution and composition of wards committees, etc. 1. There shall be constituted wards committees, consisting of one or more wards, within the territorial area of a municipality having a population of 3 lakhs or more. 2. The legislature of a state may, by law, make provision with respect to assents the composition and the territorial area of a wards committee assents the manner in which the seats in a wards committee shall be filled. 3. A member of a municipality representing a ward within the territorial area of the wards committee shall be a member of that committee. 4. Where a wards committee consists of assents one ward, the member representing that ward in the municipality or assents 2 or more wards, one of the members representing such wards in the municipality elected by the members of the wards committee, shall be the chairperson of that committee. 5. Nothing in this article shall be deemed to prevent the legislature of a state from making provision for the constitution of committees in addition to the wards committees. 243t. Reservation of seats 1. Seats shall be reserved for the scheduled castes and the scheduled tribes in every municipality, and the number of seats so reserved shall bear, as nearly as may be, the same proportion to the total number of seats to be filled by direct election in that municipality as the population of the scheduled castes in the municipal area or of the scheduled tribes in the municipal area bears to the total population in that area, and such seats may be allotted by rotation to different constituencies in a municipality. 2. Not less than 1/3 of the total number of seats reserved under Clause 1 shall be reserved for women belonging to the scheduled castes or, as the case may be, the scheduled tribes. 3. Not less than 1/3, including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes, of the total number of seats to be filled by direct election in every municipality shall be reserved for women, and such seats may be allotted by rotation to different constituencies in a municipality. 4. The offices of chairpersons in the municipalities shall be reserved for the scheduled castes, the scheduled tribes and women in such manner as the legislature of a state may, by law, provide. 5. The reservation of seats under clauses 1 and 2, and the reservation of offices of chairpersons, other than the reservation for women, under clause 4, shall cease to have effect on the expiration of the period specified in Article 334. 6. Nothing in this part shall prevent the legislature of a state from making any provision for reservation of seats in any municipality or offices of chairpersons in the municipalities in favor of backward class of citizens. 243u. Duration of municipalities, etc. 1. Every municipality, unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting and no longer, provided that a municipality shall be given a reasonable opportunity of being heard before its dissolution. 2. No amendment of any law for the time being in force shall have the effect of causing dissolution of a municipality at any level, which is functioning immediately before such amendment, till the expiration of its duration specified in Clause 1. 3. An election to constitute a municipality shall be completed, assents before the expiry of its duration specified in Clause 1, assents before the expiration of a period of 6 months from the date of its dissolution, provided that where the remainder of the period for which the dissolved municipality would have continued is less than 6 months, it shall not be necessary to hold any election under this clause for constituting the municipality for such period. 4. A municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued under Clause 1, had it not been so dissolved. 243x. Power to impose taxes by, and funds of, the municipalities. 1. The legislature of a state may, by law, a sense authorize a municipality to levy, collect and appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. A sense assign to a municipality such taxes, duties, tolls and fees levied and collected by the state government for such purposes and subject to such conditions and limits. A sense provide for making such grants in aid to the municipalities from the consolidated fund of the state and a sense provide for constitution of such funds for crediting all monies received, respectively, by or on behalf of the municipalities and also for the withdrawal of such monies therefrom, as may be specified in the law. 2. The legislature of a state may, by law, make provision with respect to a sense the composition of the district planning committees, a sense the manner in which the seats in such committees shall be filled, provided that not less than 4/5 of the total number of members of such committee shall be elected by, and from amongst, the elected members of the panchayat at the district level and of the municipalities in the district in proportion to the ratio between the population of the rural areas and of the urban areas in the district. I sense the functions relating to district planning which may be assigned to such committees. A sense the manner in which the chairpersons of such committees shall be chosen. 3. Every district planning committee shall, in preparing the draft development plan, a sense have regard to a sense matters of common interest between the panchayats and the municipalities including spatial planning, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. A sense the extent and type of available resources whether financial or otherwise. A sense consult such institutions and organizations as the governor may, by order, specify. 4. The chairperson of every district planning committee shall forward the development plan, as recommended by such committee, to the government of the state. 243s. Committee for Metropolitan Planning 1. There shall be constituted in every metropolitan area a Metropolitan Planning Committee to prepare a draft development plan for the metropolitan area as a whole. 2. The legislature of a state may, by law, make provision with respect to a sense the composition of the Metropolitan Planning Committees, a sense the manner in which the seats in such committees shall be filled, provided that not less than 2/3 of the members of such committee shall be elected by, and from amongst, the elected members of the municipalities and chairpersons of the panchayats in the metropolitan area in proportion to the ratio between the population of the municipalities and of the panchayats in that area. A sense the representation in such committees of the Government of India and the Government of the State and of such organizations and institutions as may be deemed necessary for carrying out the functions assigned to such committees. I sense the functions relating to planning and coordination for the metropolitan area which may be assigned to such committees. A sense the manner in which the chairpersons of such committees shall be chosen. 3. Every Metropolitan Planning Committee shall, in preparing the draft development plan, a sense have regard to a sense the plans prepared by the municipalities and the panchayats in the metropolitan area. A sense matters of common interest between the municipalities and the panchayats, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. I sense the overall objectives and priorities set by the Government of India and the Government of the State. A sense the extent and nature of investments likely to be made in the metropolitan area by agencies of the Government of India and of the Government of the State and other available resources whether financial or otherwise. A sense consult such institutions and organizations as the governor may, by order, Specify. 4. The chairperson of every Metropolitan Planning Committee shall forward the development plan, as recommended by such committee, to the government of the state. 243 ZF. Continuance of existing laws and municipalities. Notwithstanding anything in this part, any provision of any law relating to municipalities in force in a state immediately before the commencement of the Constitution, 74th Amendment, Act, 1992, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed by a competent legislature or other competent authority, or until the expiration of 1 year from such commencement, whichever is earlier. Provided that all the municipalities existing immediately before such commencement shall continue till the expiration of their duration, unless sooner dissolved by a resolution passed to that effect by the Legislative Assembly of that state, or, in the case of a state having a legislative council, by each house of the legislature of that state. 243 ZG. Bar to interference by courts in electoral matters. Notwithstanding anything in this Constitution, 1. The validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies, made or purporting to be made under Article 243 ZF shall not be called in question in any court. 2. No election to any municipality shall be called in question except by an election petition presented to such authority and in such manner as is provided for by or under any law made by the legislature of a state. Part IXB. The Cooperative Societies 243 ZH. Definitions. In this part, unless the context otherwise requires, 1. Authorized person means a person referred to as such in Article 243 ZQ. 2. Board means the board of directors or the governing body of a cooperative society, by whatever name called, to which the direction and control of the management of the affairs of a society is entrusted to. 3. Cooperative society means a society registered or deemed to be registered under any law relating to cooperative societies for the time being in force in any state. 4. Multi-state cooperative society means a society with objects not confined to one state and registered or deemed to be registered under any law for the time being in force relating to such cooperatives. 5. Office bearer means a president, vice president, chairperson, vice chairperson, secretary or treasurer of a cooperative society, and includes any other person to be elected by the board of any cooperative society. 6. Registrar means the central registrar appointed by the central government in relation to the multi-state cooperative societies, and the registrar for cooperative societies appointed by the state government under the law made by the legislature of a state in relation to cooperative societies. 7. State Act means any law made by the legislature of a state. 8. State-level cooperative society means a cooperative society having its area of operation extending to the whole of a state and defined as such in any law made by the legislature of a state. 243 Z. Incorporation of cooperative societies. Subject to the provisions of this part, the legislature of a state may, by law, make provisions with respect to the incorporation, regulation and winding up of cooperative societies based on the principles of voluntary formation, democratic member control, member economic participation and autonomous functioning. 243 ZJ. Number and term of members of board and its office bearers. 1. The board shall consist of such number of directors as may be provided by the legislature of a state, by law, provided that the maximum number of directors of a cooperative society shall not exceed 21, provided further that the legislature of a state shall, by law, provide for the reservation of 1 seat for the scheduled castes or the scheduled tribes and 2 seats for women on board of every cooperative society consisting of individuals as members and having members from such class or category of persons. 2. The term of office of elected members of the board and its office bearers shall be 5 years from the date of election, and the term of office bearers shall be coterminous with the term of the board. Provided that the board may fill a casual vacancy on the board by nomination out of the same class of members in respect of which the casual vacancy has arisen, if the term of office of the board is less than half of its original term. 3. The legislature of a state shall, by law, make provisions for co-option of persons to be members of the board having experience in the field of banking, management, finance or specialization in any other field relating to the objects and activities undertaken by the cooperative society, as members of the board of such society. Provided that the number of such co-opted members shall not exceed 2 in addition to 21 directors specified in the first proviso to clause 1. Provided further that such co-opted members shall not have the right to vote in any election of the cooperative society in their capacity as such member or to be eligible to be elected as office-bearers of the board. Provided also that the functional directors of a cooperative society shall also be the members of the board, and such members shall be excluded for the purpose of counting the total number of directors specified in the first proviso to clause 1. 243 ZK. Election of members of Board 1. Notwithstanding anything contained in any law made by the legislature of a state, the election of a board shall be conducted before the expiry of the term of the board so as to ensure that the newly elected members of the board assume office immediately on the expiry of the term of the office of members of the outgoing board. 2. The superintendence, direction and control of the preparation of electoral rolls for, and the conduct of, all elections to a cooperative society shall vest in such an authority or body as may be provided by the legislature of a state, by law. Provided that the legislature of a state may, by law, provide for the procedure and guidelines for the conduct of such elections. 243 ZL. Supersession and suspension of board and interim management. 1. Notwithstanding anything contained in any law for the time being in force, no board shall be superseded or kept under suspension for a period exceeding 6 months. Provided that the board may be superseded or kept under suspension in case a sense of its persistent default or a sense of negligence in the performance of its duties or a sense the board has committed any act prejudicial to the interests of the cooperative society or its members or a sense there is a stalemate in the constitutional functions of the board or a sense the authority or body as provided by the legislature of a state, by law, under clause 2 of Article 243 ZK, has failed to conduct elections in accordance with the provisions of the State Act. Provided further that the board of any such cooperative society shall not be superseded or kept under suspension where there is no government shareholding or loan or financial assistance or any guarantee by the government. Provided also that in case of a cooperative society carrying on the business of banking, the provisions of the Banking Regulation Act, 1949 shall also apply. Provided also that in case of a cooperative society, other than a multi-state cooperative society, carrying on the business of banking, the provisions of this clause shall have the effect as if for the words 6 months, the words 1 year had been substituted. 2. In case of supersession of a board, the administrator appointed to manage the affairs of such cooperative society shall arrange for conduct of elections within the period specified in clause 1, and hand over the management to the elected board. 3. The legislature of a state may, by law, make provisions for the conditions of service of the administrator. 243 ZM. Audit of accounts of cooperative societies. 1. The legislature of a state may, by law, make provisions with respect to the maintenance of accounts by the cooperative societies and the auditing of such accounts at least once in each financial year. 2. The legislature of a state shall, by law, lay down the minimum qualifications and experience of auditors and auditing firms that shall be eligible for auditing accounts of the cooperative societies. 3. Every cooperative society shall cause to be audited by an auditor or auditing firms referred to in clause 2, appointed by the general body of the cooperative society. Provided that such auditors or auditing firms shall be appointed from a panel approved by a state government or any authority authorized by the state government in this behalf. 4. The accounts of every cooperative society shall be audited within 6 months of the close of the financial year to which such accounts relate. 5. The audit report of the accounts of an apex cooperative society, as may be defined by the State Act, shall be laid before the state legislature in the manner as may be provided by the state legislature, by law. 243 ZN. Convening of general body meetings. The legislature of a state may, by law, make provisions that the annual general body meeting of every cooperative society shall be convened within a period of 6 months of close of the financial year to transact the business as may be provided in such law. 243 ZO. Right of a member to get information. 1. The legislature of a state may, by law, provide for access to every member of a cooperative society to the books, information and accounts of the cooperative society kept in regular transaction of its business with such member. 2. The legislature of a state may, by law, make provisions to ensure the participation of members in the management of the cooperative society, providing minimum requirement of attending meetings by the members and utilizing the minimum level of services as may be provided in such law. 3. The legislature of a state may, by law, provide for cooperative education and training for its members. 243 ZP. Returns. Every cooperative society shall file returns, within 6 months of the close of every financial year, to the authority designated by the state government, including the following matters, namely: 1. Annual report of its activities. 2. Its audited statements of accounts. 3. Plan for surplus disposal as approved by the general body of the cooperative society. 4. List of amendments to the bylaws of the cooperative society, if any. 5. Declaration regarding date of holding of its general body meeting and conduct of elections when due, and 6. Any other information required by the registrar in pursuance of any of the provisions of the State Act. 243 ZQ. Offences and penalties. 1. The legislature of a state may, by law, make provisions for the offences relating to the cooperative societies and penalties for such offences. 2. A law made by the legislature of a state under clause 1 shall include the commission of the following act or omission as offences, namely: A. Since a cooperative society or an officer or member thereof willfully makes a false return or furnishes false information, or any person willfully not furnishes any information required from him by a person authorized in this behalf under the provisions of the State Act. I. Since any person willfully or without any reasonable excuse disobeys any summons, requisition or lawful written order issued under the provisions of the State Act. A. Since any employer who, without sufficient cause, fails to pay to a cooperative society amount deducted by him from its employee within a period of 14 days from the date on which such deduction is made. A. Since any officer or custodian who willfully fails to hand over custody of books, accounts, documents, records, cash, security and other property belonging to a cooperative society of which he is an officer or custodian, to an authorized person, and A. Since whoever, before, during or after the election of members of the board or office bearers, adopts any corrupt practice. 243 ZR. Application to multi-state cooperative societies. The provisions of this part shall apply to the multi-state cooperative societies subject to the modification that any reference to legislature of a state, state act or state government shall be construed as a reference to Parliament, Central Act or the central government respectively. 243 ZS. Application to Union territories. The provisions of this part shall apply to the Union territories and shall, in their application to a Union territory, having no legislative assembly, as if the references to the legislature of a state were a reference to the administrator thereof appointed under Article 239 and, in relation to a Union territory having a legislative assembly, to that legislative assembly. Provided that the President may, by notification in the official gazette, direct that the provisions of this part shall not apply to any Union territory or part thereof as he may specify in the notification. 243 ZT. Continuance of existing laws. Notwithstanding anything in this part, any provision of any law relating to cooperative societies in force in a state immediately before the commencement of the Constitution, 97th Amendment, Act, 2011, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed by a competent legislature or other competent authority or until the expiration of 1 year from such commencement, whichever is less. Part 10. The Scheduled and Tribal Areas. 244. Administration of Scheduled Areas and Tribal Areas. 1. The provisions of the Fifth Schedule shall apply to the administration and control of the scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura and Mizoram. 2. The provisions of the Sixth Schedule shall apply to the administration of the tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram. 244A. Formation of an autonomous state comprising certain tribal areas in Assam and creation of local legislature or council of ministers or both therefor. 1. Notwithstanding anything in this constitution, Parliament may, by law, form within a state of Assam an autonomous state comprising, whether wholly or in part, all or any of the tribal areas specified in Part 1 of the table appended to paragraph 20 of the Sixth Schedule and create therefore a censor body, whether elected or partly nominated and partly elected, to function as a legislature for the autonomous state, or a censor council of ministers, or both with such constitution, powers and functions, in each case, as may be specified in the law. 2. Any such law as is referred to in clause 1, may, in particular, I sense specify the matters enumerated in the state list or the concurrent list with respect to which the legislature of the autonomous state shall have power to make laws for the whole or any part thereof, whether to the exclusion of the legislature of the state of Assam or otherwise. A sense define the matters with respect to which the executive power of the autonomous state shall extend. A sense provide that any tax levied by the state of Assam shall be assigned to the autonomous state in so far as the proceeds thereof are attributable to the autonomous state. A sense provide that any reference to a state in any article of this constitution shall be construed as including a reference to the autonomous state and a sense make such supplemental, incidental and consequential provisions as may be deemed necessary. 3. An amendment of any such law as aforesaid in so far as such amendment relates to any of the matters specified in subclause A, or subclause B, of clause 2, shall have no effect unless the amendment is passed in each House of Parliament by not less than 2/3 of the members present and voting. 4. Any such law as is referred to in this article shall not be deemed to be an amendment of this Constitution for the purposes of Article 368, notwithstanding that it contains any provision which amends or has the effect of amending this Constitution. Part 11. Relations between the Union and the States. Chapter 1. Legislative relations, distribution of legislative powers. 245. Extent of laws made by Parliament and by the legislatures of states. 1. Subject to the provisions of this Constitution, Parliament may make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state. 2. No law made by Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. 246. Subject matter of laws made by Parliament and by the legislatures of states. 1. Notwithstanding anything in clauses 2 and 3, Parliament has exclusive power to make laws with respect to any of the matters enumerated in List I in the 7th Schedule, in this Constitution referred to as the Union List. 2. Notwithstanding anything in Clause 3, Parliament, and, subject to Clause 1, the legislature of any state also, have power to make laws with respect to any of the matters enumerated in List 3 in the 7th Schedule, in this Constitution referred to as the Concurrent List. 3. Subject to Clauses 1 and 2, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in List 2 in the 7th Schedule, in this Constitution referred to as the State List. 4. Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state notwithstanding that such matter is a matter enumerated in the State List. 246A1. Notwithstanding anything contained in Articles 246 and 254, Parliament, and, subject to Clause 2, the legislature of every state, have power to make laws with respect to goods and services tax imposed by the Union or by such state. 2. Parliament has exclusive power to make laws with respect to goods and services tax where the supply of goods, or of services, or both takes place in the course of interstate trade or commerce. Explanation: the provisions of this article shall, in respect of goods and services tax referred to in Clause 5 of Article 279A, take effect from the date recommended by the Goods and Services Tax Council. 247. Power of Parliament to provide for the establishment of certain additional courts. Notwithstanding anything in this chapter, Parliament may by law provide for the establishment of any additional courts for the better administration of laws made by Parliament or of any existing law with respect to a matter enumerated in the Union List. 248. Residuary powers of legislation. 1. Subject to Article 246A, Parliament has exclusive power to make any law with respect to any matter not enumerated in the Concurrent List or State List. 2. Such power shall include the power of making any law imposing a tax not mentioned in either of those lists. 249. Power of Parliament to legislate with respect to a matter in the State List in the national interest. 1. Notwithstanding anything in the foregoing provisions of this chapter, if the Council of States has declared by resolution supported by not less than 2/3 of the members present and voting that it is necessary or expedient in the national interest that Parliament should make laws with respect to goods and services tax provided under Article 246A or any matter enumerated in the State List specified in the resolution, it shall be lawful for Parliament to make laws for the whole or any part of the territory of India with respect to that matter while the resolution remains in force. 2. A resolution passed under Clause 1 shall remain in force for such period not exceeding 1 year as may be specified therein, provided that, if and so often as a resolution approving the continuance in force of any such resolution is passed in the manner provided in Clause 1, such resolution shall continue in force for a further period of 1 year from the date on which under this clause it would otherwise have ceased to be in force. 3. A law made by Parliament which Parliament would not put for the passing of a resolution under Clause 1, have been competent to make shall, to the extent of the incompetency, cease to have effect on the expiration of a period of 6 months after the resolution has ceased to be in force, except as respects things done or omitted to be done before the expiration of the said period. 250. Power of Parliament to legislate with respect to any matter in the State List if a proclamation of emergency is in operation. 1. Notwithstanding anything in this chapter, Parliament shall, while a proclamation of emergency is in operation, have power to make laws for the whole or any part of the territory of India with respect to goods and services tax provided under Article 246A or any of the matters enumerated in the State List. 2. A law made by Parliament which Parliament would not but for the issue of a proclamation of emergency have been competent to make shall, to the extent of the incompetency, cease to have effect on the expiration of a period of 6 months after the proclamation has ceased to operate, except as respects things done or omitted to be done before the expiration of the said period. 251. Inconsistency between laws made by Parliament under Articles 249 and 250 and laws made by the legislatures of states. Nothing in Articles 249 and 250 shall restrict the power of the legislature of a state to make any law which under this Constitution it has power to make. But if any provision of the law made by the legislature of a state is repugnant to any provision of the law made by Parliament which Parliament has under either of the said articles power to make, the law made by Parliament, whether passed before or after the law made by the legislature of the state, shall prevail, and the law made by the legislature of the state shall to the extent of the repugnancy, but so long only as the law made by Parliament continues to have effect, be inoperative. 252. Power of Parliament to legislate for 2 or more states by consent and adoption of such legislation by any other state. 1. If it appears to the legislatures of 2 or more states to be desirable that any of the matters with respect to which Parliament has no power to make laws for the states except as provided in Articles 249 and 250 should be regulated in such states by Parliament by law, and if resolutions to that effect are passed by all the houses of the legislatures of those states, it shall be lawful for Parliament to pass an act for regulating that matter accordingly, and any act so passed shall apply to such states and to any other state by which it is adopted afterwards by resolution passed in that behalf by the House or, where there are 2 houses, by each of the houses of the legislature of that state. 2. Any act so passed by Parliament may be amended or repealed by an Act of Parliament passed or adopted in like manner but shall not, as respects any state to which it applies, be amended or repealed by an Act of the legislature of that state. 253. Legislation for giving effect to international agreements. Notwithstanding anything in the foregoing provisions of this chapter, Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries or any decision made at any international conference, association or other body. 254. Inconsistency between laws made by Parliament and laws made by the legislatures of states. 1. If any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament which Parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list, then, subject to the provisions of Clause 2, the law made by Parliament, whether passed before or after the law made by the legislature of such state, or, as the case may be, the existing law, shall prevail and the law made by the legislature of the state shall, to the extent of the repugnancy, be void. 2. Where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then, the law so made by the legislature of such state shall, if it has been reserved for the consideration of the President and has received his assent, prevail in that state. Provided that nothing in this clause shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying or repealing the law so made by the legislature of the state. 255. Requirements as to recommendations and previous sanctions to be regarded as matters of procedure only. No act of Parliament or of the legislature of a state, and no provision in any such act, shall be invalid by reason only that some recommendation or previous sanction required by this Constitution was not given, if assent to that act was given. 1. Where the recommendation required was that of the Governor, either by the Governor or by the President. 2. Where the recommendation required was that of the Raj Pramukh, either by the Raj Pramukh or by the President. 3. Where the recommendation or previous sanction required was that of the President, by the President.